Brandon K. Wright is a partner in the law firm of Franzik PC. With over 2 decades of experience as a school attorney, Brandon is a frequent presenter on issues of school law around the country. Welcome, Brandon. And I'm Linda, your webinar facilitator. I'll be behind the scenes, making sure that everything runs smoothly, as well as interacting with you in the chat. So let's get started.
Well, hello, everybody. Welcome to our conversation this afternoon as we think about some of the important and exciting trends and some case updates going on out there in the world of EdTech and things related to that from that school law standpoint. So happy everybody's joining us today. If you've got questions, we're going to try and take those between our sections today. So please pop them in the chat if you've got questions, and I will do my best to answer those as we go along today. And Linda will pause and ask me those questions in between our sections today. And we really do have sort of three sections we're going to walk through. I want to talk about AI we've got this year. In the year 2025, several cases out there on a variety of issues and some legislative changes as well that impact AI. So I want to make sure that we've had a chance to think about those things, have those issues on your radar, see how courts are analyzing that and what practical things we can take away as we look at some of those issues. We're going to spend a few minutes with, I think, some key reminders and trends when it comes to data privacy issues. I know that's always a topic that we talk about in these EdTech legal updates. We can never forget about that. It's always got to be at the forefront. And I want to mention a few things related to that. And then we will round out our conversation today talking about some social media cases. There have been a number of cases this year that impact staff and student and official school district social media accounts. And I think we want to make sure that we're staying abreast of those things and talking about it. So let's jump right in first and have the AI conversation. You know, my goal today is not to have, there's so many good resources out there on AI, and I really want to just make sure that we are keeping front of mind, especially for those of us who work in EdTech and are helping school districts navigate these issues. What are some of the key legal issues we're seeing? What are some things that are popping up? What's changed from the last time we've hung out together, perhaps, and talked about those things that are important for us as we think about that? We continue to understand some of those challenges that continue to exist. Just the access for folks. Not all school districts have the same access to platforms and infrastructure. They need to do that. The training and adaptability of educators to make sure if we are rolling it out in the school environment, our teachers ready, willing, and able to be able to use it effectively in their teaching practice and students in their learning. And then I think we continue to have those ethical concerns. Issues with bias. We're going to talk about some laws on the employee side, especially related to that. Plagiarism issues. We're going to talk about a federal lawsuit involving that. So we've got a number of issues we're going to think about in that regard. I think just by way of a little bit of review from the federal guidance, last fall, the Department of Ed issued, I thought, a really great toolkit on AI that the Department of Ed has since taken down from their website in 2025. But I think it has some really good information. As a matter of fact, I must not be the only one who thought that, because the Illinois Association of School Boards has included that guidance document as part of the administrative procedures attached to Press Policy 6235. So we know that we have access to that through our district's policies. Most districts in Illinois rely on IASB and Press for their policies and procedures. And I think that's one that we want to make sure that we're taking a look at in that regard. It really, I think, is a helpful piece, a starting point for looking at some of those privacy and security issues, how we integrate it in from a teaching and learning standpoint. So I think there's some great policy guidance in that toolkit that those of us that are press policy subscribers have access to that. Again, thinking about some of those data privacy issues, that's a front burner issue for me when it comes to AI. Is I want to make sure that we are making good decisions to use platforms and programs that are compliant with SOPA and some of that cybersecurity piece that we're going to come back to in a little bit. So I think that's got to be a component to the conversation for sure. I think that there's a way to use AI to build on the instructional core, but not replace it. A lot of AI-enabled interventions, we're seeing those become better and better, but maybe not ready to replace the human element in teaching and learning. And there's some guidance from a policy perspective from that. And then, of course, how do we make sure that educators are able to do it? And what are some of those other, policies for responsible use, how to react to concerns like cyberbullying and deep fakes and potential threats. And those things are all embedded in that as well. OCR, the Office of Civil Rights, also had an updated guidance document that's also since disappeared. We're going to talk about how some of that's been embedded in state law in Illinois for us this year, and we'll come back to that. In 2025, we did have sort of not a full replacement for that toolkit, but a Dear Colleague letter was issued from the Department of Ed back this summer that said, that ultimately the Department of Ed does have a full commitment to using AI in schools and supporting the critical role that it plays. That Dear Colleague letter includes some principles for responsible use. So that I think, again, those are things that can guide our policy decisions as school districts in terms of what we're using for us. And I think that is certainly an important point that we keep in mind, that it's educator led, that is ethical, that is accessible, that is transparent and explainable, that we meet those data protection pieces like FERPA or in Illinois SOPA and the Student Records Act as well. Those things are there for us. The other piece, just from a policy perspective, is there were a lot of changes in 2025 in the School Board Association's press policies related to AI, and added some specific provisions related to AI in various policies, including our acceptable use policy. The one that I want to focus on, there was a new procedure that was created, which asks each school district to develop an AI plan and responsible use guidelines. That administrative procedure relies heavily on that toolkit from last October that I mentioned. That's no longer available from the Education Department, but is available from the School Board Association here in Illinois. That policy says that it's the EdTech committee who's going to create or review a district AI plan. Part of those requirements make sure that plan is tasking the staff that we assign that role to make sure that any AI tools we are using are SOPA compliant and make decisions about professional development to staff about those issues. So I think if you're looking at sort of like what's on my list for this year, I think taking a close look at that administrative procedure, customizing it to what you want and need and is useful for your district or your program is really, really important. And so I think those are some pieces that we want to think about and talk about from that regard. When we get to the practical issues, what are some of the issues that are popping up? Again, I think the data privacy piece, going all the way back to 2023, the Department of Ed has made clear that that's an area of concern, that we want to make sure that whatever we're using, and especially if an educator is using an open system that doesn't have some of those data privacy protections, that it includes student data, that we may have some of those concerns for us. And that's an area that we've got to pay close attention to. What happens to this data? How is it deleted? Who sees it? Those are concerns that we've got to make front burner in terms of whatever platform or program we are using. So that when we are choosing a platform, we're able to ask those good questions. Does it do the task we want it to do? How are we using it? Do I know enough about it and its data privacy? Does it create any security risks related to student data? Those are questions we've got to ask before we jump in. And I think that we are realizing that, not all platforms, not all programs are the same when it comes to being able to answer these questions. And some have more of a commitment to that data privacy piece than others. And that's a part that we've got to keep important. And so I think it does give that possibility for that landmine for confidentiality issues. We know copyright and some, large language models borrowing, to maybe use a euphemism, copyrighted material in generating the content that it generates. That's very important for us to keep in mind. From more of the student discipline standpoint, and maybe even sort of the First Amendment issue, we do have, the use of deep fakes and other things are front burner issues, where we've got bullying and harassment, revenge porn, threats, those kind of things coming up for us. We have some case law starting to emerge on that, maybe not anything directly on point, but I think we clearly see the trend in the case law, like this Kaczynski case, which is not necessarily AI, but more just social media fake account related, but we can easily translate this into the AI world, where a student created a fake Instagram account impersonating a teacher. And the court said that was not parody protected by the First Amendment, but it was harassment of individuals in how that was used. And so, courts, I think, looking at that Supreme Court decision in Mahanoy from a few years ago, saying, look, when that action is serious or severe bullying targeting individuals, even in this case, that individual may have been an employee, not only a fellow student, that's not going to be protected by the First Amendment necessarily. And those are actions for which we might issue discipline. I think that is important. Here in Illinois, we had a change in the statute this year. So Public Act 104, 338 will take effect next July 1st, which specifically includes AI and digital replicas within the definition of cyberbullying, within the bullying statute in the Illinois School Code. Again, I suspect most of us are already operating in that form. We're already treating it that way. But of course, the General Assembly wanted to be cool and make sure that they were doing something with AI. And one of the things they did this year for us from the student side of the ledger is to include AI and digital replicas in that definition, potentially, of cyberbullying, if it's used in that manner for us. Another case from this past year comes from Massachusetts, the RNH versus Hingham School case. And this is one of the few cases out there that I found where we've got a K-12 AI issue related to a student having some academic consequences, or even some extracurricular consequences here we see for using AI to do his work. So the facts of this case generally is that the teacher and school officials determined that the student used AI in his AP history project. And he turned in some AI generated work as his own work. The school did say that the teacher had permitted students to use AI to brainstorm and identify sources, but they still had to do the work themselves. They couldn't just have an AI generated paper. But he did that. Not only did he do that, but the work that he turned in had many AI hallucinations, meaning citations to non-existent books, non-existent materials, some things that were just made up in this AP history project. And so he got a failing grade on this project. Although he was ultimately granted the opportunity to do it over and improve his grade, he did get a Saturday detention for this. And because of that Saturday detention, he was rejected from National Honor Society, although he was later admitted this is what this is about. So this kid is suing now, seeking a preliminary injunction to tell the federal court, you should issue an injunction to put me in National Honor Society because I wasn't given appropriate due process, meaning I didn't know it was against the rules to use AI. And really the foundation of this lawsuit, the argument that the student and his parents make in this case, is because the school did not have an AI policy, that there was nothing in the handbook that specifically said, thou shalt not use AI to complete your AP history project, that being denied the opportunity and being issued discipline violated his rights under the 14th Amendment and the Massachusetts Constitution as well. The school said, look, while maybe it's true that we don't have a policy that spells out in black and white what our policy on AI is, we have repeatedly taught the fundamentals of academic integrity, how to use and cite AI. We had some communications about this. There was a presentation in an English class about this. So maybe not in his history class, but they had talked about it in English class. And that's where it is. And ultimately the court said school wins, right? Or at least student is not entitled to his injunction, which, pretty much made the case go away at that point, saying, look, he knew, he was given basic due process. He was explained why he was disciplined. He was given the opportunity to explain himself. And they said, look, there's no likelihood of success on the merits here. They said this district did a thorough investigation. There was nothing to say that his rights were violated. And ultimately the school district wins this case. But I do think that this case raises the question, right? The whole argument was your policy wasn't clear enough. I didn't know that was against the rules. And so I do think that maybe this is a lesson to say, what are we doing from that policy standpoint? And certainly we see it embedded in the acceptable use policy, but is that showing up then also in the handbook? Is that happening with teachers? One of the things the student argued in this case is that some teachers let them use AI. So he didn't know that he couldn't do it in this class because other teachers let them do it. And so I think that we've got to really be having good conversation, some consistency, and make sure we know what the rules are, because that's where we get these potential claims related to due process. I didn't know what the rule was. I wasn't on notice. It wasn't in the handbook. So I want us to make sure, kind of going back to the idea that, the new policy updates from press ask each district's EdTech committee to complete that administrative procedure with those responsible use guidelines. That's an important piece for me to think about. Another issue that comes up for us in that front, we have another case from this year, the William A. case from the Sixth Circuit, where the court found that this student with a disability was denied a free, appropriate public education because they over accommodated his reading disability rather than teaching him to read. This is a student who, rather than teaching him basic reading skills, the district permitted him to rely on AI to complete his work and pass and give him credit and graduate. And the court said, look, letting him use AI to do his work and giving him good grades and letting him graduate is not a free, appropriate public education. You've got to still provide that underlying reading instruction as well. And I think this case is a really great example of trying to find that balance between appropriately using assistive technology for students with disabilities, but not over accommodating to the point that we're no longer learning the underlying skill that we're supposed to be teaching. And so I think that's certainly an important case for us to keep in mind. On the staff side, I think there's some other practical issues I want to have, on our radar. Pedagogy first. We've got to make sure staff are trained to use it so that it is effective for us. We want to think about it again as a collaborator, but not necessarily replace the role of educators in that regard. Again, making sure we've got that SOPA compliance, that cybersecurity piece is an important consideration for us. One of the things I'm seeing, and I don't know if this is a staff issue or a student issue or a parent issue, I kind of put in the middle. We have cases like this Virginia case where you had a parent and advocate using AI to generate filings and letters, and a special ed issue where the court said, look, they're creating a lot of, again, hallucinations, fake citations. I see this as a common thing. I would say at this point, it is probably daily, on average, every day, that I have parents in disputes, whether that be a student discipline matter, a special education matter, using AI to draft their communications with the school. My concern about that is twofold. One, I'm not sure that it's always accurate, right? Like in this Virginia case, you had situations where the parent and advocate's communication included a lot of hallucinations, inaccurate citations that, I think that they believed they were saying the truth, maybe, but it wasn't. And I think that's a source of conflict because we're not operating from the same playbook. Because they're believing that the AI answers they're getting are correct, and they weren't always correct. Another thing that I've seen, and I've had a couple situations where this is true, where maybe I've been communicating by email with a parent or advocate in a situation, and so I send an email, and what I think is pretty clear what they're doing is they're copying and pasting that email into ChatGPT and asking it to write the response, and then. What I find is happening is I don't think I'm actually communicating with the parent. I think the parent's just putting my email into ChatGPT and copying and pasting the response. And I don't know that we're ever actually connecting. I think we're talking past each other at that point. And I've sometimes been like, maybe we just need to set a time to talk on the phone or something, right? Because we're just trying to resolve an issue. And we're talking past each other because they're relying on AI for that communication. I think that's important for us to keep in mind. I think we also want to keep investigations in mind, where if we've got situations, we got to do more than just make assumptions, but dig deeper into that. We also know that we've got to avoid bias. We've got a couple different statutes taking effect. There's amendments to the Illinois Human Rights Act that take effect January 1 that incorporates the use of AI that has the effect of subjecting employees to discrimination as a violation. And it requires notice to employees if we are using AI for recruitment, hiring, promotion, or other employment decisions. For example, if you're using an AI platform to screen applicants to decide who you're going to interview, we have to give notice to that. And if that has the effect of discrimination, if there's bias where it screens out people based on race or disability or gender or any other protected class under the Human Rights Act, that's a violation. We also have in Illinois the AI Video Interview Act. So if we are using AI to screen an applicant's pre-recorded video interviews, we have to notify them and obtain consent. There's some additional pieces related to that, how we share it and what that looks like. So again, we have some key considerations for us about some of those issues. So I think we just again, before we move on to our next topics, and see if anybody has any questions on the AI front before we kind of move to more of a data privacy view to think about. I think we are now, as AI has become a little more universal and ubiquitous, and we're seeing it used in more aspects of daily life. We know surveys tell us that the vast majority of educators are using AI regularly in the classroom. I see parents using AI much more regularly. I see other attorneys using AI much more regularly. We've got to be ready for some of those issues that are popping up, and we're now starting to see that bleed into the case law. And I think we've got to be prepared to address that. So, Linda, do we have any questions at this point?
I don't see any questions in the chat. We'll give people about 30 more seconds to put any questions they might have in. But yeah, what a timely topic with AI. And, you touched on, Brandon, the idea of, making sure teachers have access to training on AI and that teachers are ready to use it. If you are a district that is looking to, train educators, or you want additional kind of professional development on that, please reach out to the LTC. We have all kinds of resources for AI, online courses, workshops, webinars. We have a conference coming up. So we're here to support you. I don't want to be too self-aggrandizing, but that's what we're here for, is to support schools in these difficult transitions with tech tools. So
Yeah, that's fantastic. And I think those have all been really great that I've been able to experience and encounter. So I think those are great resources. And I think we've got to make sure at the local level, our policy matches our practice, and
Hmm.
we're getting some of those ducks in a row, because we want to be ready to address those things formally when they come up. There was a point in time where none of us had social media in our policies, and now it's become such a key component of what we think about for both staff and students and the district itself. So the same is going to be true of AI.
Absolutely. I did have one question pop up. Someone asked if you could share the press policy reference for the toolkit again.
Sure. I mean, I'll just slide back to that slide real quick before we go forward, just so you've got it in front of you. But it is in policy 62235. It's the AP3. It's that administrative procedure number 3 that has that in there. I think even usually in the district, there's very few people that have that access to those press procedures. The superintendent or maybe a few other people. It's still available if you Google it and try and find it. The Department of Ed has taken it off their website, but it's available in lots of places for that toolkit. But it is embedded as part of policy 6235 AP number 3. So that's where it is.
Perfect. And I popped that in the chat. And also, we'll be sharing the link to this presentation afterwards, so you can grab it there again as well if you need. But yeah, that's the only question that we had in the chat. So if you do have any more questions about AI specific policy, please feel free to pop those into the chat moving forward as well. We can always circle back and talk about them. But let's go ahead and move on to data privacy, always a hot topic in the world of EdTech.
It absolutely is. And I know that I've talked about it a lot, and I know we hear about it a lot. So I just have some quick reminders here. We know we got to do SOPA. We got to keep up with what our obligations are in terms of keeping our policy up to date, having written agreements with any operators. When we have new operators and vendors, that we get those agreements, we post them on the website, that we're implementing those reasonable security measures. The LTC has updated those reasonable security practices within the last year. So we want to make sure that we are training, communicating with employees about those data privacy practices, and that educators know if this is not an approved operator or vendor with a written agreement with the school district, we're not using it until the district approves it. And we've got a SOPA compliant agreement with that for us. That's an important component for it. The part that I want to just spend a couple minutes on here as part of this, as a key trend I'm seeing, is on that document storage piece for employees, where employees are maybe storing school documents, student documents, electronic records that may have student information in them, sometimes maybe in a personal Google folder or a personal Dropbox. I think we've got to make sure that we're being very alert to that. I mean, just to give you a case, this case is a couple of years old at this point, maybe almost 4 years old at this point. But we've got a case from Missouri where the Supreme Court of Missouri upheld the dismissal of a tenured teacher for saving student files, including student IEPs, in her personal Google folder. I think, sometimes teachers say, well, I need to be able to access that when I'm from home. And if we need to have those cloud storage options, we got to do it in a way that is SOPA compliant through a district approved avenue, and not in our personal document storage, not our personal Google folder, not our personal Dropbox or whatever it is. Those are things that we've got to keep in mind. So I think that's kind of the next piece that we're trying to focus on when it comes to that data privacy piece. One is certainly AI. And making sure that whatever AI piece is compliant with SOPA and our data privacy expectations. But I think that document storage piece is an important one as well. And I see as a frequent issue that I'm encountering in a lot of districts. And we see there's even some litigation in case law on that in recent years as well. Now, this case in Missouri was not a SOPA case. This was a FERPA case, but the same outcome obviously would apply. And I think that we've got to be ready, willing, and able to address that. So I didn't want to spend a lot of time on data privacy today, but I wanted to make sure that we put that reminder in our brains one more time, that that's still got to be a priority. I can't delete it from the slide deck. Whenever I do an EdTech update, we got to talk about it. And I think this is one of those trending pieces that I'm seeing come to light more and more in a lot of my districts. And I want us to be thinking about, and again, communicating with employees to train and be alert about how we're using some of those cloud storage options and avoiding private cloud storage using school approved SOPA compliant cloud storage is going to be really important. There's a major difference between a school-owned Google folder and a personal Google folder with your Gmail account when it comes to data privacy. And we got to make sure staff are alert to that and understand the right way to do it. And here's the other just practical thing for those of us in the ed tech world in our schools is the harder we make it for our staff to use those tools, they're going to look for the tools on the private side that may not be compliant. And we want to make sure that we're giving them access to those resources so we can do it in an appropriate way. So I think that's an important one to keep in mind. So those are my quick hits on data privacy. I don't know if anybody has any questions about that or any other questions on AI popped up before we get into the third leg of our journey today, Linda, but which is social media. But anything else yet at this point?
Yeah, we did have one question pop up about AI. So one of our viewers asked, what about putting special ed teacher reports in AI and asking it to create a narrative?
So I think there's a role for that. And there are some platforms that do that and do that well. And some of those platforms are SOPA compliant and some are not. So I think we've got to start with some of those basic things. Are we using, an approved SOPA compliant secure platform? If you're putting it in an open platform like ChatGPT, that's not gonna work, right? We've got legal issues inherent in that if that's what's happening. And guess what? That is happening in your building, right? That may have happened today. I promise you that is happening, right? So we've got to get them the tools to have that. And so I'm not going to mention them by name because I'm not here to support any product, but I know that I've got many districts and cooperatives that have started to use some different AI platforms for exactly that kind of purpose. One, I'm very excited that I haven't used personally, but I have a client who has given me my own login to be able to use and play with that a little bit. So I'm excited here over the next couple of weeks now, finally, to be able to use it myself. And maybe the next time we get together, I will have, that experience to do that. But my understanding from some of my clients who are using some of those platforms that do that is that it's really a great tool. Mm-hmm. And I'm fully supportive of that with two caveats. One is the data privacy piece that I already talked about. The second caveat for that to me is we still have to review it. We still have to have our licensed teacher look at whatever output comes from that platform to make sure, is that really appropriate for this student? So I think it can be something that can add a lot of efficiency. I have seen situations where frankly, we can use AI to write better IEP goals and objectives that are measurable and use that data to do that. And some of those capabilities are really impressive. So I'm definitely not a no on that. I'm a yes, but I'm a yes with those important caveats of data privacy. What platform are we using? It doesn't meet that compliant. And then two, it's there to collaborate with the human, not replace the human when it comes to the IEP content.
Yeah, great advice on that. It's something that I think, we all need to be aware of is like, where is this data going that we're putting into these AI models? Because some are training their databases on our data, some are not, some are to lesser and greater extents. So I think, that's, again, we're a agnostic organization too when it comes to particular products. But, just asking those good questions about what exactly are the data privacy issues with these different AI platforms. Great advice.
Yeah, and I think one other thought on that before, unless there's another question, I'll jump onto social media on that. But my other thought is, I think that's kind of our job as ed tech leaders, right? I'm assuming those of us who are listening today are people who have those responsibilities, right, for some of those ed tech issues in our districts and in our buildings. And if we know teachers are begging or salivating to have an AI tool to help them make their job easier, those things exist. And I am told they're not prohibitively expensive, some of these things, and are really effective tools. And so if we want our teachers to use the right tool, we got to make that available to them. Otherwise, they might default to using the wrong tool that may not be legally compliant and create other issues for us. And I think that's what's important to keep in mind.
Absolutely. I couldn't have said it better. So I think that's it for the chat. Again, if you have other questions about either data privacy or AI, please leave it in there. But let's move on to our last section, which is our favorite social media. We love to see it.
There are so many cases here, and I could spend 3 hours just unpacking the cases that we have. And so I just want to mention a few this year that I think are, I just want to mention a few cases this year that are specifically important on this social media issue. A lot of those come back to the employee piece first, right? And just by way of big picture reminder, right? The Supreme Court has told us over time that for public employees who work for a unit of government like a school district or other public entity, that our speech is protected by the First Amendment only if it's on a matter of public concern and only if it's not part of our duties. And then there's the balancing test, right? The Pickering-Connick balancing test, where we look at, does the impact of the speech outweigh the employee's interest in terms of disruption to the employer and other factors. And we have a number of cases this year where that's popped up. Just for time purposes, I'm not going to get into great detail on these cases, but I want to give you the high points of them. One comes from the First Circuit that was appealed to the U.S. Supreme Court. The Supreme Court denied cert here in June of 2025, so no further appeal. This case involves a teacher who, after she was hired, the school becomes aware of some controversial memes that she had posted to TikTok before she ever was an employee. And a really important part to this case is that these are TikTok posts that this teacher made before she was ever a teacher in the school district, before she ever applied for a job. This was before that was there. They were posts that made fun of people based on gender identity and race and had some racial overtones. So when you look at the PowerPoint, you can see the controversial things that she put in there. Ultimately, she was fired for that. She sued, saying that was her free speech under the First Amendment, but the court said no. Even though she was speaking as a private citizen on a matter of public concern here, you get to that balancing test, and the balancing test said, look, she can't effectively be a teacher if she's denigrating the identities of students. And so they said it didn't matter that she made those posts before she was a teacher. She tried to argue, how can I be subject to your rules for things I posted before I was an employee? And the court said, under the relevant First Amendment jurisprudence, the issue is not so much what you said, but the effect it has, right? And so it doesn't matter whether you said that today or yesterday or a year ago, if it's impacting your ability to do your job as a school employee. And therefore, they found that her speech was not protected, and the Supreme Court denied cert. A case from the Seventh Circuit this year, a case from Illinois, is the Hedgepeth case, where a teacher was terminated after posting inflammatory comments to Facebook about the death of George Floyd back in 2020. And ultimately, again, this is a case where the Seventh Circuit said, because of the impact that it had, it prevented her from effectively performing her job as a teacher, and that therefore she could be dismissed. So again, even though she was speaking as a private citizen on a matter of public concern, the Seventh Circuit really emphasized it was the disruption caused by the posts. It wasn't so much the content of the post, but the disruption caused. That's there. And I think sort of the key encapsulation of this standard from the Seventh Circuit binding on us in Illinois is sort of this paragraph, right? Where the court said, zooming out, the district produced ample, undisputed evidence of actual disruption. This evidence shows that the teacher did not lose her job because she expressed her views on a matter of public concern on Facebook. Rather, she lost her job because she posted a series of vulgar, intemperate, and racially insensitive messages to a large audience that included alumni and others. The district's undisputed evidence demonstrated that these posts predictably rippled throughout the community, causing disruption among current students and faculty, at school board meetings, and even attracting local and international media attention, and emphasizing that this was the teacher's third strike and not an isolated incident. The district reasonably concluded that the scope and intensity of the disruption created an insurmountable barrier to the learning environment, and therefore it was not protected by the First Amendment. So I think going back to that policy perspective, right, we want to make sure that teachers are maintaining that professional and appropriate relationship with students, parents, staff members, and others. That's certainly there for us. And I think just from that policy perspective, that policy 5125, policies are there to help us, right, navigate these pieces, that we have that expectation that when school employees are using personal technology and personal social media, that they understand they still have to adhere to those high standards of appropriate school relationships, and that when you're posting information online that others access and can access, and even in that Hedgepeth case, her account was set to private, but it was shared, right? People took screenshots, other things were there, and so it was still disseminated. That can still violate policy and be an extension of the workplace and not necessarily protected. So, I don't want to spend too much time digging into policy here too much, but I do want us to think carefully about that and understand we've got some key court decisions this year on those issues. I think the other issue we want to talk about is when it comes to social media that's used for official school purposes, right? The Supreme Court in 2024 decided Linkey versus Freed. While this was not a school-specific case, there was a companion case that we're going to talk about in a second that was a school case that really looks at when you're a public official, in this case, a city manager. I think we could use the analogy in the school setting, a school administrator, a school official. When you are using your personal social media for any official purpose, then that might convert it into an official account for those purposes. This case involved a city manager who would post to his personal, I use scare quotes there, personal Facebook page, city business, and sometimes people commented, and sometimes he responded to those comments related to city business, and he ultimately blocked this other guy who kept making rude comments to him about the city's pandemic response. But the Supreme Court said, look, when you're posting about job-related topics on social media, it doesn't matter whether or not you label it your personal account. What matters is how you use it. Do you have the authority to speak on the government's behalf or the school district's behalf? And are you purporting to do so on social media? And the court said it doesn't matter, right? Whether you label it as personal, what matters is the use and effect. The companion case to that was the O'Connor-Radcliffe versus Garnier case, which involved a school board member and their social media and their decision to block or hide comments as well. After the Supreme Court decision, Linkey versus Freed, that school board member in California posted on her Facebook page this little disclaimer that says, this is my personal page, run exclusively by me. All views on this page and in every single post are my own and do not constitute official government speech, nor represent the position of the school district, and cite Linkey versus Freed. I asked the question, does this kind of disclaimer help? Because the Supreme Court said it doesn't matter whether you label your page as personal, it's how you use it, right? Are you using it for an official purpose? And so, on remand in that case, the Ninth Circuit this year said, yes, the school board member was using it, and therefore there was a violation of the First Amendment for blocking other people and violating the First Amendment in that regard. So we see that from the Ninth Circuit. Another case we have interpreting Linkey versus Freed in the school context as a case that comes from Montgomery County, Maryland, the Foldy case, where there was a Twitter account or X account, which was the MCPS Staff Pride account. And you had members of the community who would post replies and tweet, it's X, but I'm of a certain age, so I'm going to call it Twitter because that's how my brain works, would tweet things at them. And so they would delete the comments or block people. And those people sued saying, this is an official school account. It violates the First Amendment. You have to be viewpoint neutral in who you block and what comments you delete. And here the court said, given the custom and use where they posted about official school events, it would give a member of the public the impression, right, that this was an official account associated with the school, and therefore they couldn't engage in viewpoint discrimination by blocking people who made comments they didn't like. So I think that what we understand is that when we have district operated social media, we are sometimes creating that limited public forum, which means any regulation of speech has to be content neutral. We can't delete things just because we don't like it or it's critical. Although we can have time, place, and manner regulations, we don't have to allow comments at all. But if we do, we have to be content neutral in that piece. A case where that was at issue that the Seventh Circuit decided this year doesn't involve K-12, it involves higher ed, but the same rules apply, was the Krasno versus Mnuchin case, which involves the University of Wisconsin, where you had an individual, Madeline Krasno, who would post comments to the Instagram and Facebook pages of the university related to animal cruelty. The university said, hey, we have a policy that says we can delete any off-topic comment. And so we're going to delete her comments when they are off-topic and not related to the post. And while the university won at the district court, the Seventh Circuit disagreed and reversed. And the Seventh Circuit said, we think that this individual has standing to bring the lawsuit, that the posts were limited public forums, and that their ill-defined off-topic comment rule was not reasonable and was not viewpoint neutral, and therefore violated the First Amendment. So I think we've got to be really careful about understanding when and how we can delete and block users from the school social media. And that while certainly the court said we can have reasonable time, place, and manner restrictions, we've got to make sure we're operating that in a way that is truly viewpoint neutral, and that can be implemented in a way that doesn't have the effect of having too much discretion and too much ability to remove posts just because they are unpopular. I just share another case. We've got another appellate court that said similar things in the PETA versus Tabak case. This is a case from last year from the DC Circuit Court of Appeals. It actually involves the same animal rights advocate, Madeline Krasno, as the same plaintiff, suing, in this case, the National Institutes of Health, in that regard. What makes, I think, this case interesting, why I included, is that this district, or the NIH, used a keyword filter, sort of using an AI platform to automatically hide comments that had certain keywords in it. And here the DC Circuit Court of Appeals found that also, violated the First Amendment in that regard. So I think we've got to be very careful about that. We also see that we've got some Illinois decisions, some PAC decisions over time about that. So we've got to make sure that we understand, we may not be able to delete comments just because we don't like them or because they are critical, recognize that we're creating a limited public forum and treat it as such. And I think we need to use our social media to fill that void with positivity rather than negativity. When we leave our social media unattended, some troll is going to fill the void, right? So let's make sure that we are getting what we need from that. So just some important updates we see from the Seventh Circuit and other cases on that social media front, both staff social media and district social media. There's also some interesting student social media cases this year, but I kept it to the staff and the district official social media for purposes of our conversation today. So let me turn it back. Linda, do we have any other questions? Anything else we want to talk through before we round things up today?
So I did get one question in the chat here. And again, if you do have questions, please feel free to pop them in. One of our viewers asked, would you recommend having comments turned off for every social media post if it's a school account?
I certainly have clients that have made that decision. I don't know that I feel so strongly that I would say I recommend it. I think you're going to have to make that decision as a district and decide, how you want to use that forum and what to do. I think more and more districts are making that decision because people tend to, not behave in a civil manner. And I think that the legal restrictions, kind of force us into that direction. So I think if that's a decision that we make, we can have those time, place, and manner restriction and regulations. We've got to make sure we're doing that. I know that some districts have had some practical issues with implementing that. Depending on the social media platform, sometimes you have to make that decision with each post. And if you forget, and then once comments start coming in, it might be difficult to start unwinding that, and on which post do you do it and not do it. So consistency is going to matter. So if we make that decision, we've got to be ready to do that in a manner that is going to be truly, truly consistent.
Yes, we had one more. So the same viewer asked, if someone forgot to turn off commenting, does it violate if there's some comments and then later they go back and turn off commenting?
I think once you've made that post, I think you've opened that post up. I think if you turn it off later, I think there's a concern there about, are we really regulating content from a viewpoint neutral standpoint? So I would just be very cautious about that at that point in time.
Yeah, it's definitely like that retroactive can be difficult. And then we had one more comment here, just someone chiming in saying that removing comments is very tricky business when being consistent.
Yeah, I think that's where we've got to look at that big picture. Unless it's truly obscene, a threat of violence, I think you got to let the negativity just rest once that comment is made.
All right. Well, I do not see any more comments. So from us at the LTC, thank you for attending today. Brandon, thank you for being here with us. And we hope that you have a wonderful holiday and that we see you again in the future on another webinar. And so, yeah, safe travels, everyone. I know that it's a little bit snowy here in Illinois, and it's been a crazy time traveling the last few days. So thanks again for being here, and we'll see you in the future.
Thanks, everybody.